And I'd like to introduce Ellen Efros, who will introduce our program for today. Thank you.
Good afternoon, everyone. For those of you who are not familiar with Ken, I hate to say it, but you're probably living under a rock somewhere, especially in our community, because he gives presentations and lectures on a variety of subjects, even though he is retired, allegedly. He is a distinguished professor emeritus of political science and the Bud Shortstein Professor Emeritus of American Jewish Culture and Study at the University of Florida. He has written and spoken on a number of different issues affecting religion and politics in the United States, and the public conflicts and crosses on the ballot. The religious cases before the Supreme Court have not gone away. They are ever present. They will continue to be ever present. And Ken is going to bring us up to date today on what the Supreme Court has done during this last term and what we might expect during the current term, the new term. And with that, I'm very pleased to welcome Ken.
Good afternoon, and thank you, Ellen, for the invitation to participate in this class and for the very nice introduction, which I'll try to live up to. I kind of feel like I'm among friends here because I recognize a lot of you from various places, and I want to give a special shout out to three people I haven't seen for a while. Ray Jones, Liz Williams, and Deb Rossi. It's great to see your faces again, and I long for the day when we can be in the same room. I'm going to start the PowerPoint now. So whenever I talk about legal issues, I think it's important to warn the audience about my background so they can understand my perspective. When I occasionally am invited to speak at the law school or at a conference of attorneys and the like, I always like to tweak them a bit by saying that I'm the only one in the room whose mind is not disfigured by a legal education. And I say that with apology because I know at least some of the people here are on the call are lawyers. But I approach this topic as a political scientist, as a social scientist. And I am particularly interested in what I call the regime of religion and state in the United States. By regime, I'm talking about the institutions, the norms, the practices, and so forth that are utilized when questions arise about the role of religion vis-a-vis the state and vice versa. And ultimately, my concern is about how the decisions of courts affect governance, the way governments can and do behave, which is somewhat different than I would typically expect of attorneys. I'm going to do something I don't normally do in talking about these topics. I'm going to be offering you today not just a description of what's happening, but a perspective on that. My perspective is fairly straightforward. I believe that the Supreme Court has, for the last 15 years or so, have been invoking religious freedom with decisions that, in my mind, actually reduce religious freedom. It made me a little nervous to say this out loud because in all the years I taught at UF, I was very careful not to express what I thought could be interpreted as political or ideological views. I don't think our job is to use the platform we have to expound on our political preferences. But in this case, given the nature of the audience, I think it's appropriate for me to say why I'm concerned about the direction of the court. And I was still, a couple of days ago, mulling over the fact whether I wanted to say this when I read, I think it was in Monday's New York Times, a column by a distinguished attorney named Donald Iyer, I think it's pronounced. And in this op-ed piece, he made three observations that are very much on point. First, he said of the court as it was reconvening on Monday, that as the court begins a new term, regrettably, its recent history suggests that it lacks a majority of justices with sufficient concern about the basic continuity and integrity of the law or the ability of government to function. A pretty damning indictment by one lawyer of a group of other lawyers. And then in referring to the Supreme Court term that ended last spring, he said perhaps most unexpected and disturbing were decisions elevating rights of religious assembly over local public safety rules related to COVID-19. And then he also referenced the case that I'm going to be talking about, the Philadelphia case, Fulton. And he said of that decision that this result appears to violate a court precedent of over 30 years, holding that religious believers, like everyone else, are bound by generally applicable neutral conduct requirements that are not aimed at any religious group. Now, knowing that this column appeared in the New York Times, you might imagine this is just simply an expression of a liberal perspective by a newspaper that has a fairly liberal editorial line. You might expect to hear this from somebody on MSNBC. But the striking thing is Donald Iyer is actually one of the founders of what's called the conservative legal movement. He worked in high positions in the Justice Department under Presidents Ronald Reagan and George W. Bush. So he is someone who is a judicial conservative. But in this column, he argues that now that conservative judges have a clear majority on the court, they're behaving just like the liberal judges who he wanted to replace, going beyond the case at hand to effectively legislate from the bench. So the concerns that I expressed are not unique to one or the other side of the ideological spectrum. When a man of Iyer's reputation shares them, it suggests that there's something wrong with what the court's been deciding. So let's see about this issue. Most of what I'm going to be talking about today is the so-called free exercise clause. This was part of the First Amendment to the Constitution. And I think it's safe to say that the overriding purpose of both clauses that affect religion in the First Amendment were essentially to assure religion a high degree of freedom from state regulation. Look at the language for a moment. This is the very beginning of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, we're relatively sure that the first clause about establishment of religion simply means that government, not just Congress, but today any branch of government at any level, none of those branches should grant favoritism or legal authority to religious organizations. They are intended to be part of the civic sphere. They are not part of the state because, as James Madison observed many years ago, the state has no religious competence and should not be making decisions about religion. The free exercise clause more or less reinforces that the state should be neutral toward religion, between religions, and between religion and irreligion. That is to say that individuals should be free to do what they want or say what they want under most circumstances without the state penalizing those words. Now, you might ask yourself, why would the state want to or be inclined to inhibit anyone's religious free exercise? What kind of religious groups would likely suffer this kind of behavior? What was the court worried about here? Well, I think the history of the first of the jurisprudence about the free exercise clause makes it very clear that the kinds of religion or religious groups likely to be discriminated tend to be smaller, non-traditional, and one might say unpopular religions, rather than mainstream or widely accepted religions. And if you look at the decisions the court has made in the 20th century and 21st century that have expanded religious free exercise, you'll notice that almost all of the plaintiffs were small or unconventional religions. For example, in the 1960s, the Amish community in Wisconsin sued the state, arguing that the requirement that students have complete the 12th grade, 11th to 12th grades of education, hurt their community, that students knew all they needed to know after they finished 10th grade, and keeping them in the public schools threatened the integrity of the community. The Supreme Court agreed and said that under those circumstances, the Amish were allowed to withdraw their kids from education after they'd completed a 10th grade education. A few years later, well, actually, a long-term process, the Jehovah's Witnesses are a group that has been a plaintiff in a disproportionately large number of free exercise cases. Many of you know Jehovah's Witnesses are fairly aggressive in proselytizing. They send their members door to door. They engage in public worship. They clearly and actively pursue converts to their tradition. And not surprisingly, in many communities, they have not been particularly popular. And ordinances were passed prohibiting public worship, prohibiting door-to-door proselytizing, and so forth. And most of those cases were won by the Jehovah's Witnesses, in spite of the fact that they were a majority faith, not particularly beloved by most other faiths. Jewish groups played a central role in challenging efforts to utilize the public schools as a means of promoting Christianity. That is, they took on efforts to promote prayer in the public schools, which was invariably Christian prayer. Again, this was not always a popular decision, but the court has been fairly consistent on this issue. And finally, even though they're not a religious group, you can take another small, largely unpopular group and show the role they've played in expanding free exercise. During the Vietnam War, you had a lot of conscientious objectors. These were people who asked to be relieved from the obligation to engage in combat, not to avoid military service, but not to engage in combat should they be members of the US military. And up until that point, to be classified as a conscientious objector, you had to have a clergy person from your religious tradition attest that the person's reading of the religious rules was legitimate. Well, Seeger, who was not a conventionally religious person, had developed a deeply based moral critique of combat and war. And the court ruled that he was entitled to that you couldn't give religions an exclusive role in deciding who should be a conscientious objector. So the expansion of free exercise has typically been at the behest of and to the advantage of small and non-traditional religious groups. Now, why would free exercise be a problem? And it's worth pointing out here that even though I'm going to argue that I think the court has moved in the wrong direction, I accept that there are legitimate reasons to debate the whole question about free exercise of religion, and particularly whether or not individuals should be exempted from the law based on religious grounds. The first thing to say about free exercise as a problem is it was never intended to be an unlimited right. Years ago, a good friend of mine who taught me a lot about the Constitution gave me some very good advice. He said, Ken, never read part of the Constitution without reading the rest of the Constitution. And I think the point is that if you read the Constitution holistically and not simply pick out certain phrases, you'll see that none of the rights there is meant to be absolute or unlimited. Free speech has limits, virtually everything else has limits. And since the 1878 to 79, when the court issued its first real ruling on free exercise, it has been recognized that the free exercise of religion can be limited if it threatens public order. So let's say you happen to be a member of religion that believes that you should appease God periodically by sacrificing children, and there have been some faiths in the history of the world. The court would say you can believe that's necessary, but if you act on it, you will be subject to the full penalty of the law for murder. So we obviously don't say that every behavior that is contrary to the law should be protected under free exercise. And the court has long said that there may be reasonable restrictions on the time and place of public religious observance. You see that in airports when groups proselytize, they're increasingly given a particular space and are not supposed to engage in proselytizing outside that space. Even if we recognize the limited right, James Madison, who is the founder of the Constitution, the father of it, and one of my political heroes, observed many years ago that there will always be debates about where you draw the line between religion and state. And as you see in this quotation here, he says it's going to be impossible in every conflict to draw a line between religion and civil authority so as to avoid collisions on what he called unessential points. Now, for the people involved in these conflicts, the points aren't unessential, but the notion is that implementing a concept like free exercise is always going to have gray areas. Typically, conflict based on free exercise arises in two kinds of cases. There are occasions when the civil authority, the law, may ask of people or demand of people certain behavior that those individuals believe violates their religious scruples. And in other cases, the law may ask them to do things that's against their religion. In other cases, the law may prohibit behavior that they believe is required by their religious scruples. And all of these cases raise the general question about should religious behavior be exempt from a public law that believers think violates their religious scruples. That's really the big issue that we have to deal with in these cases. And I would argue it's not simply should behavior be exempt, but if so, how do we make those distinctions? Okay. Well, the ruling precedent, and there have been several over time, but the ruling precedent in free exercise cases was established back in 1983 by a case from the state of Oregon, Employment Division v. Smith. Oregon had, as many states, a problem of people utilizing illegal drugs. And they therefore created an office that was designed to educate the public about the dangers of, I think it is Schedule C drugs, I can't remember specifically. And they employed, with state funds, drug counselors. As a condition of their employment, members of this particular branch were required to acknowledge by signature that they themselves do not use illegal drugs. That was a condition of employment. It wouldn't be very credible to have people telling others don't use illegal drugs if they themselves were violating the law. Well, as it happens, there were two members of the Native American Church who had been hired as drug counselors. Both of them, I should point out, had been alcoholics, had overcome the alcoholism, and were considered to be very good at talking to people about the dangers of addiction. But as members of the Native American Church, they followed a sacrament that involved using peyote, a prohibited drug, in their religious rituals. And when confronted about this, they refused to say that they would stop engaging in this ritual. They were duly fired by the state of Oregon, and they argued that their firing violated their free exercise rights under the Constitution. In effect, they were saying they should be exempted from the rule that drug counselors had to avoid illegal drugs if those drugs were used as part of an illegal or part of a religious ritual. The court denied the appeal by a 6-3 vote. And in doing so, it utilized a set of questions that are typically utilized when the court faces a claim that rights have been denied. And in a sense, it's three questions. And if any of those questions can be answered no, the state's restriction on religious freedom is not sustainable. So in effect, to win a case, you have to show that in any one of these three cases, the state did not comply with the policy. First of all, the court asks, did the state's policy target any specific group for selective enforcement? Did it, for example, identify Native Americans or the Native American Church? Well, the court said in this case, this was not intended to harm or limit the Native American Church. The legislature and the administration were unaware, in fact, of this potential problem. And it was just an unavoidable consequence of a generally applicable law, a law that would apply to anybody of any tradition if they utilized illegal drugs and were employed as drug counselors. So the state's action passed the first test. The next test is the policy narrowly tailored? That is it the least intrusive way that the state could achieve its goal without impinging on religious freedom? And the court decided here that because this provision was limited to drug counselors and it was not broadly applicable to state employees, it really was narrowly tailored. And so the policy in principle was not discriminatory. And therefore, on that ground, the state was on solid grounds. The third criteria that the court used in this case was whether the state had what was said to be a, quote, reasonable basis for the policy that intruded on religious freedom. And it's safe to say that there's almost no public policy that could not be argued in terms of being reasonable. The state had a problem, it found a solution, it was narrow, so of course it was reasonable. The really controversial aspect of this decision, apart from limiting the ability of individuals to gain exemption, was that it made it actually much harder for individuals to be exempt. Prior to this decision, when the court considered any appeal based on religious free exercise, the third question was tougher for the state. The state had to show in what was called strict scrutiny that its policy was not only reasonable, but essential. It had to show, quote, a compelling state interest for engaging in the policy which restricted free exercise. What this case did is basically get rid of strict scrutiny and say all the state had to show was that it had a reasonable basis. And again, as we know, that's not hard to do. So because the state's action satisfied the three tests, the court ruled that its infringement of religious freedom was within the bounds of the Constitution. Now, this decision had three important consequences. As I just said, it made it much harder for individuals to use religious rationales in claiming that their free exercise rights have been infringed. And that was clearly one of the purposes of this decision. The decision was so unpopular among religious communities of all stripes that Congress was induced to pass with, I think, 2 negative votes, something called the Religious Freedom Restoration Act, which among many provisions said that in future cases, the court must follow strict scrutiny rather than the ordinary scrutiny it followed in this particular case. Well, as it happens, the constitutionality of RFRA came to the court a few years later, and the court issued a complex decision, but with regard to strict scrutiny, the justices lectured Congress that the Supreme Court, not Congress, can decide what standard the court should exercise when it's making judgments about this or any other violation. So the Smith decision did emerge as a significant barrier to free exercise appeals. And if you look at the free exercise appeals over time based on religion, you see after the Smith decision, the proportion of acceptable, that is winning cases, dropped precipitously. They didn't disappear, but they were much less common. So why did the court make this decision? Well, the essential argument in the majority opinion is that it would be chaotic if you allowed every individual to decide for themselves whether a law applies to them or not. And in the majority opinion, the statement was straightforward. The unavoidable consequence of democratic government must be preferred to a system in which each conscience is a law unto itself, or in which judges weigh the social importance of all laws against the centrality of all religious beliefs. The first part of that sentence actually echoes the very first court decision on free exercise in 1879, where, again, they made a distinction between belief and behavior and said that even if you think a law is contrary to your behavior, to your belief, you can believe what you want, but you can't act on it. But there's something important here. Why the reference to democratic government? Well, keep in mind the restrictions on free exercise that this opinion refers to are those that government decides, and democratic government is ruled by the majority. So in effect, what this decision says is that any restriction that is favored by the majority in a democratically decided system should have authority, and that exemption should be very rare, if not at all impossible. There were also criticisms of exemption by some liberals on another ground, that it violates the Establishment Clause because it gives the authority of government to a religious group or an individual. But that wasn't the main thrust of it. Now, there are several things that are tremendously ironic about this decision. Start with the fact that in the 80s, our political discourse had reached a point where it was common for Republicans to claim that Democrats were hostile to religion, and therefore to paint the Democratic Party as a party that doesn't support God or doesn't support religion. This was a common aspect of the political discussion then, and you hear it a lot to this day. Well, the irony is that the author of the decision was none other than Antonin Scalia, the most conservative member of the Supreme Court at the time, and somebody who we know was a serious Catholic in his position. So you would not have expected somebody with this position to take this argument. It's a peculiar phenomenon. Secondly, it's worth pointing out that Justice Scalia, in making this decision, did not need to address the question of strict versus ordinary scrutiny, because the state of Oregon did not ask him to do that. In fact, the Attorney General of Oregon said that he was horrified by this. He said that they were confident that Oregon would win its case under strict scrutiny, and I think he was right. They probably would have. So Scalia reached out beyond what he needed to decide. And again, in the conservative legal movement, one of the criticism of judges was you don't judge cases that don't need to be decided. And when you do judge cases, you should only judge on constitutional grounds when there is no other option. In this case, Scalia didn't need to address that, and he certainly didn't need to make it an argument that had constitutional implications. It is worth pointing out that despite the fact that this law did limit free exercise of religion in a narrow set of cases, it did not mean that the court would never accept such claims. And a case that came out a few years later made that point very clear. This case emerged from Hialeah, Florida, which many of you are probably familiar with, which under the leadership of its mayor, who was subsequently convicted on various federal financial crimes, nonetheless, a municipal ordinance was passed that made it illegal to kill animals as part of a religious ritual. Now, this law was aimed at a particular religion that was present in Hialeah called Santeria. Santeria is an Afro-Cuban religious faith that merges elements of Catholicism with various kinds of nature religion. And the Santerians did, in fact, kill animals, chickens typically, in the course of their rituals. The court decided 9-0 that Hialeah's law was unconstitutional. And it was very simple. It was clearly aimed at Santeria because they had no objections to the dog track in Hialeah for veterinarians to put down a dog that was injured, in other words, killing an animal, nor did they restrict, say, the presence of butcher shops or slaughterhouses, which also killed animals. It was clearly targeting Santeria, and for that reason, it was thrown out 9-0. So it was possible under some cases to win a free exercise challenge based on ordinary scrutiny rather than strict scrutiny, but it was more difficult. Still, it could be done. So what the court has been doing since then, it didn't begin in 2014 and it continues to the present day, but has, in my mind, been converting exemption from generally applicable laws based on religious considerations as a preferred freedom, something that appears to overwhelm any other freedom that exists in the Constitution. In the Hobby Lobby case of 2014, the corporation did not want to follow the Affordable Care Act, which would have required them to provide and pay for contraceptive services in the medical insurance policies for their employees. They said they had religious objections to contraception. And I stress, we're not talking abortion here, but simply birth control. And that they did not want the corporation to be required to provide it. And the court ruled rather stunningly that Hobby Lobby, as a corporation, had free exercise rights and was able to get by this particular provision. You're probably all familiar with the Masterpiece Bakery case from the same year, where a baker in Colorado was asked to provide a cake for a reception honoring a wedding by honoring a same-sex wedding. He said that was contrary to his religious scruples and sought that exemption from the anti-discrimination law on sexual orientation. The court ruled in his behavior on what I have to say is one of the least impressive decisions I've ever read. They went through the record and claimed that the state commission, which found there had been discrimination, was hostile to religion when that record shows nothing of the sort. But in any event, they argued that the rights of this individual business person trumped those of the state's anti-discrimination law. In 2020, a Catholic order, the Little Sisters of Mercy, sought to be exempt from the minimal requirements of the the Affordable Care Act. When the Affordable Care Act was passed, it recognized that there were religious institutions that would have objections to it. So they negotiated a very simple means of evasion. All any such organization had to do was to fill out a one-page form saying they object to this requirement on religious grounds, and they would not have to provide contraceptive provisions in their insurance. However, the insurer had to provide it at no cost to the organization. So they were not directly involved in any way in contraceptive. Even that minimal effort was too much, and the Little Sisters of Mercy sued, and the Supreme Court upheld it, said they should have been totally exempt they should not have been asked to go through the burdensome act of submitting a one-page form. In Espinoza, decided last year, one of the cases I talked about earlier this year, the question was whether the state of Montana, which had passed a law giving tuition scholarships to parents of children in high school education, could restrict such contributions to only private schools that were not religiously affiliated. Montana had a very strong constitutional provision saying state money cannot be used to support religious institutions. Now, by the time this case made it to the Supreme Court, the Montana Supreme Court had already struck down that law, and the law had been repealed by the legislature. So there was no law there at all, no policy. Yet the court heard the case and upheld the argument that the religious freedom rights of the plaintiffs were being inhibited, even though there was no policy that would have inhibited them. Again, it's overreach in a constitutional sense. And finally, in the case of Our Lady of Guadalupe, two teachers at Catholic schools had asked for additional time off during the semester, one because she was having a difficult pregnancy, the other because she was getting treated for cancer. In both cases, the Catholic schools fired them. Instead of giving them the time off, they sued on grounds of sex discrimination. And the court decided that religious schools were exempt from employment discrimination lawsuits for virtually all of their employees. In the past, it had only been ministers, but now it effectively made a janitor a religious employee, and therefore the school could not be said to be in violation of the employment discrimination laws. So the point here is that the court has bent over backwards to take religious exemptions and grant them to pretty much everybody under almost any circumstances. And the trend, and the two things about these decisions I want to stress, these are not the kind of accommodations that the court traditionally made in the 20th century. To begin with, those 20th century cases involving the Amish, Jehovah's Witnesses, and the like were not zero-sum cases. Giving the Jehovah's Witnesses the right to go proselytizing door to door doesn't restrict any other religious group's freedoms. it may be annoying, but it doesn't restrict anybody's freedoms. There's no loser in that particular case. It just brought the Jehovah's Witnesses within the pale of the law. The other thing that's important about those decisions is that those people who lost in most of those cases, the people who were facing discrimination, were generally those with less power. And you look at the cases I've just mentioned, and you'll see where the power lies. Hobby Lobby has religious freedom given to those who own the company. But the 20,000 women who work for Hobby Lobby stores, their religious freedom was diminished because they were not given access to contraception because their employers had a particular objection. Same in Masterpiece Cake. One baker had religious rights, but those who were seeking his services in the public sector didn't get it. Little Sisters has a very well-regarded and large network of homes for children who are not yet been placed in foster care and the like. And again, the nuns don't have to worry, their religious rights were sustained, but the women who worked for them lost their contraceptive coverage under insurance. The Espinoza case, presumably the relatively small number of people who wanted to send their kids to private religious schools, they, in theory, got that right, but the vast majority of Montanans who had clearly voted against that policy, their religious rights didn't matter. And in Guadalupe, you had two teachers, both of whom were in a very difficult position, who got fired, and yet the Catholic Church and the schools were apparently exempt from these restrictions. So these are very different uses of the religious freedom. Okay, the case that came in late last year, Fulton versus the city of Philadelphia, has a fairly simple history. The city of Philadelphia used the Catholic Social Services, among other groups, to provide for foster care for children that were dependent. This was a very common phenomenon, many communities do it, and the relationship had existed for many years without any problem. Then Philadelphia passed a city ordinance which said that any contractor for the city must accept same-sex marriages as legitimate. So if a building contractor that was doing something for the city provided insurance for the workers, which covered the family, the same had to be true for any worker who was married to a person of the same sex, not seemingly an unreasonable decision. Catholic Social Services refused to sign the contract, and they said they should be exempt under the Constitution. And they sought that exemption in a case that went to the Supreme Court. Now, the court ruled unanimously in favor of Catholic Social Services, but it was really one of those weird cases where everybody who voted had a different reason for voting. And many of the people who voted with the Catholic Social Services said, well, they didn't like the decision, but they felt Catholic Social Services deserved to continue its relationship with the Philadelphia agency dealing with childcare. The court decision was written by the Chief Justice, so that requires some special attention. And he had a very convoluted argument, I'm sorry to say, where he said the contract they were being asked to sign did include a mention of exemptions that could be made if the agency decided those exemptions were in the best interests of the child. Now, up to this point, it's worth stressing, there had never been an exemption requested, nor had there been an exemption allowed. So all that existed, again, was a theoretical possibility that exemptions could be issued. And then the court said in a decision that I still don't understand, that because the exemption existed, the policy was not a generally applicable law, and it was therefore not neutral, and it therefore violated the requirements of ordinary scrutiny, and that the Catholic Social Services should be given their exemption and allowed to refuse to serve any same-sex couples who were seeking to adopt a child who had been under court control. It's clear that the decision is so, and it's worth emphasizing one point. Justice Roberts said that the courts is not saying that every agency of government is required to create religious exemptions to government contracts. That is not their point. But it's kind of a distinction without a difference, as we'll see later on. It appears that Roberts and Justice Barrett cited, who were the key figures in this decision, were concerned that the majority of judges were going to go further and argue against the Smith decision that any government policy must have an exemption based on religion, no matter what the policy was. And that's their real concern, and they both feel that would be disastrous. And indeed, a number of the minority opinions, the predictable ones by Judges Alito and some others, did say they didn't see any reason why Smith shouldn't be overturned. So it was a strategic decision, and it reads like a decision meant to get people to vote in favor, even though the argument is not very persuasive. All right, where is this going? What kinds of trends are we seeing? It's worth mentioning that there are 4 cases that are on the court's docket for this term involving religion. And a number of them involve similar claims to free exercise that we've seen in Hobby Lobby and some of the other cases that I talked about. One of the newspaper stories that I read recently about the new court session observed that, in the past, you might find one Supreme Court case about religion a term. Now you're seeing 4 or 5. So I think several things are happening. I think where the court is moving is kind of a weird 2-pronged approach. If government, and again, we're talking about any level of government, any form of government, any official government, provides any kind of benefits to citizens or groups, religion must be included, religious groups must be included as recipients. Now, many states have laws which preclude the use of state money to support religious institutions. But effectively, the Supreme Court is overriding those rules, legislating from the bench, and says those states must still include religion among the beneficiaries. And that's potentially a problem because it involves intermingling of public money and religious money. But I think that's pretty much been decided based on what I've seen. Secondly, the court also seems to be saying if any level of government imposes any burdens on individuals, the state must exempt religion. And this came up in the COVID-19 cases where all sorts of public assemblies were limited to avoid the spreading of the virus, particularly after the Delta variant. And a number of governments had such laws, but they imposed a small set of businesses or organizations that they felt were essential. And therefore, the Supreme Court jumped in and said, well, religion has to be exempted, even though religious assemblies are strong candidates as super spreaders, because people are typically in close proximity, typically unmasked, they're singing, they're shouting, they're talking. It's exactly the circumstances that promote infection. And the research that's been done has shown a number of church meetings that have led to these kinds of surges. And indeed, in a number of cases, some pastors who've been vocally opposed to masking and vaccines have been among those who died. But I think that's where the court is going. Any exemption to any law on any basis, you must also exempt religious reasons. And in effect, I think they're saying that, again, any government exemption has to include religion. And so it's to the point, I think, where we're turning to a position that the founders and the Supreme Court in the 19th century felt was very problematic, where every individual now is a religion unto him or herself, and there's no way you can limit the religious exemptions. So you're familiar with Alachua County, for example. If you want exemption from the mask mandate, you have to be granted it on religious grounds, even if your religious community doesn't accept the grounds. And the classic example here is Roman Catholicism. The Pope Benedict has been the current Pope has been very clear that it is in fact not merely an option, but it's an obligation on Catholics to be vaccinated and to comply with public health concerns. because after all, Catholicism, in his view, is a pro-life religion, and both vaccines and maskings help to preserve human life. And when people have made arguments about the origins of these vaccines related to earlier strains of genetic material that was taken from aborted fetuses decades ago, the Pope has been very clear that's not a reason not to get vaccinated. But many Catholics are finding grounds in Catholic theory to justify these exemptions. And you know, I feel sorry for anybody in any local government or state or federal government who has to decide if this is a legitimate claim or not. And the practice, in fact, is going to be if you ask for a religious exemption, you're going to get one. Even though it's clear that's not the reason why people are refusing Mass, it's much more political in nature. The long-term effect of this, as I argued when I spoke last time, is that the government is in effect privileging the major religions over smaller religions. And you can see this really clearly in a couple of recent events and the traditional use of religious free exercise cases to defend unpopular small religions has been turned on its head. And I want to show you how this is observed. Two states during the last 6 months had received requests from prisoners on death row to have their spiritual advisors with them in the execution chamber, Alabama and Texas. In both those cases, the court stayed the execution, and the Supreme Court has agreed to hear the Texas case in this upcoming system. Now, consider for a minute the people who are seeking to have their religious free exercise granted. We are talking about two people whose lives are going to be taken by the state, who are not appealing their sentences, who are not challenging their convictions, but simply want a religious advisor there to comfort them. There's no physical danger to having them in the chamber because we're not electrocuting person or using poison gas. And there appears to be no good reason why this shouldn't be granted. But in his response to the court's stay, the Attorney General of Texas, Ken Paxton, made an interesting observation. He is defending Texas' case to deny the individual in that case, the condemned person, to have his religious advisor in the chamber to comfort him. And he said in language that should curdle your blood, that a state may not impose policies coercing an inmate to do what his religious tenets forbid, which is in fact true, does not mean that it must accede to his every religious demand. Now, what you see here is we've got a whole trend in granting exemptions. It's become much easier, and members of the court would like to make it even easier than it is now. Yet here you have somebody in Texas. Again, Mr. Paxton is an extremely conservative attorney general. He was the one who spearheaded the effort to pass the abortion restriction law, which you've read so much about, saying, well, you know, I'm sorry, this guy, you know, this prisoner, he's not entitled to this. So we'll give religious free exercise to somebody who claims on very specious grounds that they have religious objections to masks. But somebody who simply wants to be comforted by a religious advisor on the eve of his execution, that person isn't really worthy. And I think this really illustrates very nicely that what should be a provision that defends minority religions in a society driven by majority rule, who therefore need more protection, to take those rights away from such people and only grant it to larger and more dominant religious traditions. And I think, as I said, far more people are losing religious freedom than gaining them from these kinds of decisions. And at that point, I will thank you for your attention, express the hope that you followed what I know was not always an easy argument, and open myself up to any questions that you might have.
Alice Gridley has her hand up. Go ahead.
Okay, Alice?
Ken, thank you so much for such an interesting talk. I'm just curious about, oh, now the name escapes me, where a business is considered a person
Oh, the Hobby Lobby case.
Yeah, is there any hope that that could ever be overturned?
Well, I should defer to the lawyers among us here, but it's worth pointing out that for certain reasons under the law, even before this case, businesses were treated as if they were persons. So this is not something they did just for this particular decision. And I would imagine you can probably make arguments that that's not an unreasonable thing to do. So I think it would be very difficult to get that whole thing changed. And I don't, to be honest with you, I'm not so well acquainted with the particular conditions that make this seem appropriate for businesses, you know, in other cases, but I think it's unlikely to change. It's kind of the same rationale in Citizens United as well, about organizations having constitutional rights that individuals may or may not have.
Alice, just to add to what Ken said, I think with the current composition of the court, likelihood of Hobby Lobby being overturned is extraordinarily remote.
Yeah. In fact, the recent courts have expanded Hobby Lobby. When it was passed, there was a great deal of emphasis on it's a narrow decision. It only applies to small, closely held corporations like Hobby Lobby, which is basically a family-owned shop. But that distinction has been wiped out by other decisions over time. And now pretty much any corporation that would want to, I think, could win a case that it has religious free exercise rights.
You know, a Chick-fil-A baby next.
All right, we have a question here from the Oak Room.
This is perhaps a kind of simple-minded question, but so many of these arguments are so difficult and convoluted. I wonder, do they really help direct future behavior? And I think about teachers or parents trying to explain this to their children, some of these outcomes, and it's just so difficult that I wonder if it's diminishing regard for the court itself.
Yeah. Well, it's a really good question. Speaking generally, I think it is fair to say that it is intrinsic to the nature of the task of the judiciary that its decisions are going to be nuanced and complicated. And it's important to understand that most of the Constitution speaks in terms of concepts. Now, there's some language that isn't when it says that, you know, nobody shall serve as a representative who has not attained the age of 21 years. That's literal. But when we say that the state shall not establish a religion or that the right to free speech should not be restricted, those are concepts, and how you implement them often depends on time, place, and circumstance. So I have some sympathy for the challenge that judges face in these kinds of cases and why the decisions are seen to be so nuanced. I'm not aware of any recent study, but there was a study some years ago about the respect for the court, and it examined the decline in respect for the Supreme Court. And I should point out, this is far enough back when the Supreme Court was the most highly regarded institution within the government. It used to be highly respected. But after the 60s and 70s, which included a period when the court ruled against mandatory school prayer in public schools and the like, the court's reputation went down. But the research that was done at that time suggested it wasn't the religion cases that were really critical to this case in the broad sense of the term. It was, or to this trend. It was much more that there were a variety of decisions that struck at majority rights that some members of the public resented. And maybe in some way, this is the beginning of the religious nationalist movement, white supremacy movement, and so forth, that a lot of common practices were deemed to be unconstitutional, not just prayer in state schools. So I don't know that this adds to the problem. I think one of the problems is that the court will issue nuanced decisions, and those get distorted in political conversation. Now, you know, as I said, I'm not reluctant to criticize Scalia for making a decision that didn't need to be made. He could have left strict scrutiny intact, and we would have been spared a lot of legislation in a lot more cases in the future. But I'm not sure that this really hurts the courts. I think it's more people get angry when what they believe are their rights are restricted. But again, I pity school teachers who try to, for example, teach about religion in the schools, despite the fact that the Supreme Court has said that there's no reason religion can't be treated in the schools as a appropriate element of the curriculum, provided there's no proselytizing as part of it. But where you draw the lines, if a teacher is lecturing about religion and the law but is wearing a cross or a Star of David, does that convey a message? I mean, again, these are tough questions. And it's clear there's a lot of violation of these rules at the state and local level because nobody files a lawsuit. When I used to teach a class about religion and politics in America, I would ask my students how often in their experience in public schools, they felt that they were proselytized, encouraged to join a religion, typically Christianity. And a majority raised their hands. And these were smart kids. So I think in a sense, it's tricky to enforce these under any circumstances.
Anne
Yeah,
Marie,
Shirley has her hand up, and then we'll go to Bud.
well, Anne Marie had hers first. Go ahead, Anne Marie.
Thank you. I'm fascinated by, I guess, all the individuals who think that the Supreme Court doesn't respond to the, I guess, the vagaries of time, and people who say that the Supreme Court ought to keep up with changes in American society. And then we have issues like this that come up where you say to yourself, well, maybe this is not what those individuals, those critics had in mind, because talking about basically cherry picking which religions seem to be most acceptable in terms of leading the charge, that just, I see what you're saying, and I think the pattern is very persuasive about what you're saying. But what I wanted to just mention is that major religions and what construes major religions now is not what always was considered major religions. You don't have to go back 150 years to realize that Catholics who are part of several of these cases just cited was not considered as a universally accepted religion. And also that there, well, I'll leave it at that, but I wanted to know about the minor religions issue. And you did cite the Texas case about the inmates. So that evidently was the no-go, the stopping point in terms of opening this up. Are there any cases that are so currently under consideration in lower courts that might shoehorn this issue and basically spotlight it to try to break into this majority minority picking and choosing which are the winner religions and which are the losers?
Yeah, well, I don't, that's not, of course, a legal distinction, as you know. I actually think in the Texas case, the plaintiff might win, despite, the comments of the state of Texas, which reflects, yes, we're expanding religious freedom, but not for this kind of person. And the reason is sort of an odd one. Back when the Religious Freedom Restoration Act was reviewed by the court, they struck down most of the provisions. They said there's no evidence that states and local governments are engaging in religious discrimination on a systematic basis in most of these areas. But they said there are two areas where there's compelling evidence of discrimination. One is land use decisions, i.e. zoning, and the second one is prisons and jails. Many localities have been accused of manipulating zoning laws to keep out religions they don't like. In the modern period, of course, that's Islam. Where also all of a sudden lots of governments decide that having a mosque is somehow going to create dangers for the community. And the other one is prisons, where it's argued that people who profess minority religions have real difficulty being able to practice them in jail, even when the law says they should. Congress was emboldened by that dissent or by that decision in RFRA, and they passed a law explicitly granting federal jurisdiction in cases involving land use and prison challenges. And the law is known, and I'm not making this up, as the Religious Land Use and Institutionalized Persons Act, which is called RLUIPA. And if you want to get your students' eyes to glaze over, start talking about RLUIPA. But the point is that prisons in particular are seen as a place where you have people who in principle seem to be likely to be discriminated against if they practice non-traditional religions. And so I think there's a possibility, and greater than there were in the other cases, that the court might actually decide in favor of the inmates in this particular case. And that would do something, I think, to establish that free exercise does not only apply to certain categories, but I don't see anything more direct. The other thing that's worth pointing out is that Congress, in the peyote case, the Smith Employment Division v. Smith, later ruled that the use of peyote on federal lands does not violate the law. So as long as the religious ceremonies are held on tribal lands, it's perfectly legal. So again, you occasionally do get ordinary statutes that limit that. But beyond that, you don't get much change. But it's a good question. Thank you, Anne-Marie.
Shirley, go ahead.
I can. Thank you so much. You make it so comfortable to understand. Once thing becomes in legalese language, it's not comprehensible to most of us. And when you add nuance to it, it makes it where it is comprehensibly impossible. So my question is there any standing or any cases so far by atheists or non-religion, except maybe for the conscientious objector that you described? Does non-religion have any standing in this fight for freedom of religion or non-religion?
Yes, there have been a number of cases where the plaintiffs have been the Freedom from Religion Foundation and other, and also more secular groups like ACLU and Americans United, where you've had atheists or agnostic plaintiffs who have indeed succeeded in challenging particular decisions. Typically, those cases don't reach court because I think the lawyers on the other side realize that they'd probably lose. And so they negotiate some kind of solution. There have been two cases actually in Alachua County where this has happened. In one case, a church that was providing free outdoor meals in Southeast Gainesville to homeless people was told to cease and resist by, I think it was the city rather than the county, but I could be wrong. They contacted the Justice Department, which sent the city or county a letter saying that they would be prosecuting them because they were violating, RFRA, the Religious Freedom Restoration Act. And the city negotiated a deal and no court case occurred. The second case occurred on the University of Florida campus, where in response to a donor's request that several biblical phrases be put on the decoration of a new building that the donor had paid for, the Freedom from Religion Foundation threatened to sue, and an agreement was made to kind of offset each biblical prayer or each biblical quote with a quote from a famous non-believer. So like 2 Voltaires equals 1 Ecclesiastes, that sort of thing. And again, you can argue it sounds silly, but in a way it makes more sense. The Freedom from Religion Foundation consists mostly of people who used to be, in their own words, fundamentalist Protestants. And they have come to reject that particular tradition. And so in certain ways, they're much more aggressive than the ACLU or Americans United. And they're quite effective. They, for example, if you drive by the old water tower in Stark, they were the ones who got the cross off the water tower there. And when Stark responded by putting the 10 Commandments outside a courthouse, they were able to insist that the Freedom from Religion Foundation should also be given space, and they won that one too. So they annoyed the hell out of people on the other side on this particular issue, but they've become a force. And I've talked to some of their lawyers, and they're a lot of fun to talk to, even though I don't share their perspectives.
Thank you so much, Ken.
Yeah.
Go ahead, Bud.
Buddy Shorstein had a question?
Yes, it is. Hello, Ken. It's good to see you, and thank you for a wonderful presentation. My political background makes me curious as to how the votes went on these cases. Were they consistent? Were they generally the Republican appointees voting one way and the Democratic appointees voting the other way? Of course, that's the key to, making changes in the future.
Okay, pleasure. I should tell the rest of you that the reason I felt we had to recognize Buddy is that he contributed the endowed chair that I was privileged to hold for the last few years at the University of Florida. So he's always a patron, and appreciate that. Yeah, it depends in terms of the partisan makeup of the court. It kind of depends on the period you're talking about. During the Warren Court, when the tendency to grant exemptions to these smaller, less traditional groups developed, Earl Warren was very good at managing the court, and he managed to get most of these decisions made no more than 7-2, 8-1, or 9-0, because he was very careful to wait until a consensus developed before he proceeded. But this was also a time, I think, when establishment, let me put it this way, establishment Protestants, because that's who most of the judges were, and Catholics, tended to be fairly moderate on questions of church and state. And so it was, in a sense, easier, I think, to get that particular pattern. Then that pattern persisted for a while under Justice Berger. But once Rehnquist came in, it became, as we got more polarized, it became more and more a partisan issue, where you typically have today all the conservative judges voting in favor of exemptions and all of the liberal judges, or most of them opposing them, depending again on who is the plaintiff. Generally, the liberal judges are more sympathetic to plaintiffs from small religions and minority religions, and the Republican judges are more sympathetic to Catholicism and mainstream Protestantism and so forth and so on. It's not absolute, and you do get the unanimous cases like Hialeah, where I couldn't imagine anybody disagreeing that that was unconstitutional. It just was so good. But even in some of the Philadelphia case, they all found reasons to support the outcome, even if their reasons for doing so were different. But the court, as Mr. Dooley, the famous Irish commentator, said, the Supreme Court follows the election returns, and that is to say, the composition of the court, of course, changes eventually, but the views of the court change. And it's remarkable to me, the thing that really is striking, how in so many of these cases, the Chief Justice, who was considered to be the great victory of the conservative movement, has moved to the center on these issues. He has been working very hard on a lot of these issues to keep the court out of the political maelstrom. He did this on the Affordable Care Act, as we know, and I suspect he's trying to do it on the Mississippi abortion case. That would be my guess. And in Philadelphia, he got Justice Barrett, the most junior member of the court, to go along with him and to co-sign his appointment. So I think it's clear that the Chief Justice is very alarmed about the degree to which what he now sees as a majority on the court, of which he's not a member, that really wants to reach out, decide cases, and legislate from the bench, which is precisely the criticism that they used to make of liberal judges. So I think that's going to be an interesting process. So we'll see what happens.
And one of the things, Ken, I think you have to add to this mix is the fact that Trump really took advantage of vacancies on the federal courts, the district courts, and the courts of appeal. And a lot of those cases now are coming down without a controversy. So they're not even making it to the Supreme Court. And we're going to continue, I think we're going to continue to see that pattern as long as we have a conservative bloc sort of holding the Supreme Court where it is.
I would agree.
The likelihood of much of this changing at least in the near future, I think, again, is very remote.
Yeah, the court is the last institution to change. And it's worth pointing out, the conservative legal movement didn't start, last year. It's something that started in the 60s. And it took them almost a half a century to reach the point where they had a working majority on the court. And at that point, it was 5-4. So a switch by the Chief Justice on these cases could still hold it off. Now, of course, there's 5 people who were appointed by conservative Republican judges who, it's clear to me, are different in nature than the kind of people who used to be appointed to the court. There are a lot of ideologues. And I think that makes it harder to bring together a majority, except on weird decisions like Fulton, for example. So yeah, I don't see a lot of change ahead in the direction that I would like to see it change. I see more movement in this direction until at some point there'll be a reaction against it, but maybe not in my lifetime.
Does anybody else have any questions for Ken, or should we let him get back to studying? He's been
Oh, we
talking-
have one more from our Oak Room.
Okay, thank you, Julie.
Yes, I was just wondering what you think of court packing because now it's such a conservative court. Do you think that's a good or bad idea?
Well, let me go back just to the foundations of that. It surprises people to learn that the size of the Supreme Court is not fixed in the Constitution. And it wasn't established until the Judiciary Act was passed in the late 1800s, I think. I'm not sure about the date. And that over time, the size of the court has gone up and down, and it can do so by ordinary legislation amending the Judiciary Act. So it does not require a constitutional amendment to make that change. But it would require, again, majorities in both the Senate and the House. And again, given the diversity that's inherent in the Democratic Party, I think it's going to be hard to get that decision to go through because it's seen by people as politicizing the court, but the court is politicized. I'm often frustrated by court decisions, and part of me thinks it would be nice to see politicization, especially since the last three judges appointed to the court, one could argue are illegitimate in some sense. Judge Gorsuch was appointed for a seat that was open during the Obama administration and which Mitch McConnell refused to allow hearings on, which I consider wildly unconstitutional. Justice Kavanaugh, of course, had serious allegations of sexual harassment, which the FBI did not investigate because Mitch McConnell determined what questions they could ask and who they could see. And Justice Barrett was appointed very, very late in Trump's term, which Republicans had said had used as the reason why, Justice Gorsuch or why President Obama should not appoint the next Supreme Court justice. So part of me says I have a lot of trouble with the legitimacy of this court, given the way in which the three most recent judges were appointed. And so part of me says this might be the circumstances that would justify enlarging the court. But again, I think then you get questions about how efficient the court is and the like. So I think, one thing that political scientists are aware of, which I think is not always true of people in the legal profession, is we ask what are the likely unintended political consequences of these structural changes. That's why most of us, for example, argued against term limits, seeing far more problems than advantages, and why I think the experience in many states has validated that kind of concern. Until those questions are hashed out and discussed at great length, I'm a little cautious. But I wouldn't vote against a representative who supported it at this point if it came up. Is that enough on the fence for you? So,
Yeah,
my tendency as a professor was always to try to make sure that the students understood I'm giving them the possibilities. And so.
I think the likelihood of court packing, at least in the lifetime of people on this conference call or Zoom call, whatever you want to call it, it's probably pretty remote.
Yeah, as is restricting the court's jurisdiction, which is another thing that has come up and not
Just
gotten.
come up with the court packing issue.
Yeah.
That's all we have from here.
Okay, well, that's all we have on Zoom. So everybody have a good afternoon. And Ken, of course, thank you so much again for your participation and for your insights. And we always appreciate your presentations.
Thank you. I always enjoy it.
Thank you.
Thank you.
Thanks again. Take care, everyone.